Much indeed. The story about the email reminded me of a tale told about an English journalist who was always penniless called Claude Coburn. And he would receive letters from his creditors demanding payment of this bill or that bill. And he would eventually write to all of them and say, let me tell you how this works. Right? Whenever I get a bill, I put it in a basket in my living room. Each year at Christmas, I stir the basket, take out 5 bills and pay them. Any more letters from you and you're out of the competition. So anyway, David, thank you. Benny, thank you for the invitation. It's a huge pleasure to be back in Israel and a wonderful pleasure to be in this room with these people. In this room, the connections between law and religion are numerous, almost taken for granted. We're up to our eyes in the connection between law and religion. I want to really talk a little bit about the decline in the connections between law and religion and what this has done to us, particularly in our thinking about commandments and absolutes. The title given there was the title I gave to Benny when disappeared. The title I gave to Benny when I first agreed to do this, but the present title is De-sanctification of Law and the Problem of Absolutes. And I say in this room, it's taken for granted that we can talk about law and religion. But if I were to present a paper on the de-sanctification of law to some of my colleagues at NYU, they would say, de-sanctification? We never even knew it was holy. They would say, sure, back in the day, centuries or millennia ago, law was all bound up with religion. Trial was by combat or ordeal so that God could render a verdict. The boundaries of private property and of cities were consecrated by religious processions. Treaties were deposited in temples so that the gods could supervise their implementation. Contracts were spoken of as sacred, and that actually meant something. Writs and processes sounded in liturgy and magic as much as in rational inquiry. The sovereign, conceived of as the fount of justice, was anointed with the oil of gladness at the hands of priests and prophets. Certain laws were regarded as untouchable by human rulers because they dwelt in justice with the gods, which is something from Antigone that Jonathan mentioned a little while ago. And the sanction of divine authority was taken for granted as the key to the viability of the legal system. But that was then. Centuries, millennia ago. A few relics of this sanctity remain, some incantations. God save this honorable court. Maybe oaths. The testimony are still taken on Bibles. Bishops are still legislators in the United Kingdom, and there are still chaplains at executions, but nothing that would warrant a great deal of excitement about law, religion, and de-sanctification. But the de-sanctification I want to talk about is not just the disentanglement of religion from law. I'm going to be thinking of it instead as a process whereby certain kinds of meaning and value are drained away from legal practice and legal institutions. Again, just in the last session, Jonathan asked, what happened to modern law when it became so morally impoverished? That impoverishment I'm going to talk about today. Certain kinds of meaning and value are being drained from legal norms and institutions. It's a process described by the early 20th century sociologist Max Weber in his late writings about the rationalization of law and the general disenchantment of the world. And for those of you who have the package, you'll see some pages from Weber there, and also some pages from Jürgen Habermas, who comments on Weber's thesis. But we're talking about the withering away of a spirit of transcendent normativity, a spirit that has in the past sustained certain legal absolutes, and I want to talk about the problem of moral and legal absolutes in an age characterized by this kind of disenchantment. So understood in this way, the de-sanctification I'm going to be talking about is not necessarily about religion at all. True, the transcendent normativity that has withered away is something that might once upon a time have been associated naturally with religion, and it wasn't inappropriate to use words like sacred to refer to it. But it's not necessarily about religion, and some Weberian discussions, some discussions by Weber himself, talk about not just the decline of religion's involvement with law, but the disenchantment of religion itself. That religion itself is being rationalized, tamed, domesticated, made safe for a modern calculating world. Anyway, religious or not, a dimension of transcendent normativity is supposed to have gone from the law and from the evaluation of law. We are now blinking, clear-eyed in the hard light of day, and in that situation we can no longer apprehend certain kinds of deontic requirement that legal provisions used to make, used to embody, or certain kinds of deontic principles that law used to respond to. That's what I want to talk about in this evening's lecture. Now, a body of practical reason can be desanctified as to its form or as to its content, or both. And I'm going to begin by talking about desanctification of the form of law, a process described by Max Weber in his late work, and it's particularly the work towards the very end of his life in the large, unwieldy volume called Economy and Society. In that work, he describes what he calls the rationalization and formalization of law, a process that develops alongside the growth of an increasingly complex economic system. Legal machinery is needed to resolve increasingly complex conflicts of interest and to deal with increasingly complex arrays of transactions. The calculability of the functioning of the coercive machinery of government is absolutely prerequisite for the development of a market economy, but that calculability comes at a cost. Law, he says, in the modern world has such complex tasks to perform and so many technical conceptions to relate to one another that it has to develop a conceptual apparatus of its own. Ordinary language categories won't do, nor will the categories that are made available in classic moral theory or natural law theory. Law has to produce calculability, but it cannot produce intuitive calculability. Instead, in order to guarantee its consistency and its systematicity, events and transactions have to be characterized in law's own terms, which are no longer intuitive categories. So you say, if something is X, then it is Y. You have the characteristic if-then structure of legal discourse, but X and Y are now going to be technical terms, rather than if something is a promise, then it must be fulfilled, which is an intuitive notion. So a legal description of a transactionary event, together with a set of accompanying conditions, will generate more or less deductively a legal description of consequences, but the transactions, the events, the conditions, and the consequences have to be classified in the conceptual matrix of legal logic, which has been established precisely to make all this work. And the result is technical law, increasingly distant from the comprehension of the layman. A legal specialist is now someone who has gained the ability to manipulate these specifically legal concepts, but lost any inclination to associate them with intuitive or ordinary language meaning, or the meanings that we might find in ordinary moral expression. And all this is part of, as it were, the increased calculability of the world, the disenchantment of the world, the draining of the world that we see and count on of a certain form of value. Our ability to control everything by means of technology and calculation seems to require that the ultimate and most sublime values have withdrawn from public life. They have retreated either into the abstract realm of mystical life or to the fraternal feelings of personal relations between individuals. And we can still describe that as law if we want to, but we're dealing with a different phenomenon from the public presence of a legal system or legal systems. Now, it's Weber's view that these processes are very uneven, different countries, particularly across different legal systems. His description obviously fits systems in continental Europe that work with codes, with strong logical structure. In Anglo-American law, by contrast, there wasn't so much codification, and the common law and its methods, which Weber disparaged as charismatic judging and inductive case-to-case methodology, still continued to be dominant. There was much less in the way of legal science in England and the United States as Weber understood it. The sentiments, even in Europe, the sentiments of some laymen demanded a more intuitive, perhaps even more moralized body of law. They thought law should have recourse to a meta-positive, objective, natural law with an emphasis on ideas like justice and dignity in their ordinary sense. So there was all this pushback that Weber describes, particularly in the passage that I've given in the package of materials, but it was all futile, according to Weber. The reproduction, this is Habermas commenting on Weber, the reproduction of social rights was far too complex now to be comprehended in the meager normative motifs of natural law. Once the process of rationalization was underway, questions concerning the institutional embodiment of morality are shoved aside. And according to Weber, the role played in the development of law by purely emotional factors, such as the so-called sense of justice, represented just a flight into the irrational, and it wasn't going to achieve. So this was a one-way, inexorable process. He even thought that common law jurisprudence was declining, even in its strongholds. He thought the increasingly technical character of law was irreversible. Modern law could not now be regarded as anything other, and these are Weber's words, a rational technical apparatus which is continually transformable in the light of expediential considerations and devoid of all sacredness of content. Well, these developments obviously made it harder overall to approach law in moral terms. Certainly it was not easy to sustain positions associated with things like, I don't know, the sanctity of property or the sacredness of contract. One can hardly think of property rights and contracts having sacred status now that contract and property had become, in effect, technical terms whose normativity was determined deductively within a relatively closed system. There seemed now something quaint and old-fashioned about regarding these as representing, in any sense, legal absolutes. I do want to say, though, quite a bit more about the American situation. Weber regarded the trajectory of American law as being, in its underlying logic, fundamentally like this, but having a different immediate development. So I want to focus a little bit on American jurisprudence just because it presents a picture of de-sanctification, the same thing, only one that's slightly different from the one that Weber presents. Max Reinstein, who was one of Max Weber's early American editors, presented Weber's account of technical rationalization as the victory of a certain sort of legal formalism. Now, where I live, legal formalism is regarded as decadent and irrational, and sometimes the word theology is used to discredit it. Compared with legal realism, which, whatever the excesses of some people like Jerome Frank are concerned, has really taken hold in American jurisprudence, not just in the cult of judicial personality, but in the fact that law needs to be phrased in a way that is open to policy science, open to social science. I'm thinking particularly of the work of Felix Cohen in a great article called Transcendental Nonsense and the Functional Approach. So legal formalism is seen as an irrational relic. Legal realism, or maybe just a general openness of law to policy science, seems to be the trajectory that American law has taken. And it looks like this would be an exception, because it's no longer treating law as this closed system, but it's insisting at every stage that we be able to restate the problems of law in policy terms, in economic terms, and discuss them. But I want to talk about that extensively, because here's the point. The policy science to which law is open could be described, I guess, as a certain sort of morality, but it's a morality with a de-sanctifying momentum of its own, and it too challenges the possibility of the sacred, challenges the possibility of legal absolutes. It by no means represents any sort of return to natural law ideas. It's the language of economics, either cost-benefit analysis or the wealth maximization approach of the formal economic analysis of law. And despite its being certainly a non-formalistic framework, it is no more hospitable to older deontic principles or to considerations of justice or human dignity than was the case with the older formalist discourse. But same overall process, different local trajectory. This represents an aspect of de-sanctification that is no longer simple formalism, no longer simply a function of the operation of a technically designed formal code, it's now a substantive matter. In some ways, it's the emergence of exactly the realistic policy science that the realists called for in opposition to formalism. Its failure to accommodate ethical absolutes is no longer a matter of legal form, even though it is, in a sense, a matter of the formalization of the modern science of policy. And from here on in, I'm going to be talking not just about, in a sense, the de-sanctification of law, but the de-sanctification of the moral insights that are assembled in order to criticize, evaluate, and change law. So de-sanctification is working on both sides of the law and morality divide. Weber's account focused mostly on private law, and the kind of sacreds and absolutes that went out the window were sacredness of contracts, inviolability of property rights, and so on. But we also find as great a normative loss in public law as in private law. Let me just say a little bit about this. Weber's account is less directly helpful here, but nevertheless, the processes whereby erstwhile absolutes were drained of their deontic normativity is important to follow in this case as well. Let's begin in criminal law, with those criminal law prohibitions that used to be seen as representatives of ancient mala in se. You know what I mean by mala? Evil in themselves, like killing. Thou shalt not kill. Now, even they are no longer conceived, certainly they're no longer presented in the law in directly deontic terms. They are technical in their presentation. There's no categorical norm against homicide presented directly to the populace. Instead, the style of modern criminal law formulations is to address just the decisions and problems faced by officials in regard to killings by citizens. So you distinguish various sorts of killings from one another, and then you attach certain penalties to various sorts of killings. And if there's any sort of thou shalt not kill, it's a result of us overhearing this conversation among the officials. Oh, they must not want us to kill anybody. That's why they're distinguishing first-degree murder from second-degree murder and then associating a penalty. But you can search for days and not find anything directly deontic addressed to the citizens in the criminal codes. Hans Kelsen was convinced this was an important feature of modern law, that it addressed itself mostly to officials of the state. For Kelsen, the law consists exclusively of an instruction for a government agency to apply a punishment under a set of defined circumstances. Kelsen thought that if we infer a duty upon the subject to avoid the conduct to which the punishment is attached, this duty, this ought, is, so to speak, an epiphenomenon of the directive concerning the sanction. We overhear the instruction about this being sanctioned and draw our own conclusions about what we're supposed to do and not to do. But according to Kelsen, the only true ought in the situation is the ought addressed to the official. Now, very famously, H.L.A. Hart said that's not true. Hart said the whole point of law is to guide the conduct of the citizens. And it's a very, very resonant and sympathetic passage where he says that, but his insistence on this is simply dogmatic, rooted in an old-fashioned sense of what it is that law must do. It was certainly not grounded in any of the ways in which modern legislation is expressed. For if, as Blackstone thought, the very essence of right and wrong depends upon the direction of the laws to do or to omit them, then our laws no longer try to get at the essence. We define the mala in se in exactly the way that we define the mala in prohibited. We express the mala in se in exactly the way we define the offense, we distinguish it from other possible offenses, we set out various reasons that people might have for avoiding punishment, and we lay down what the punishment does. That's all we do. One might say, one should say, that this is just a matter of draftsman's technique. Perhaps we were never going to find a thou shalt not kill written in the books of positive law. Positive law is never just an application of moral or religious ideas. It involves specification, or as the natural lawyers call it, determinatio. In the modern world, lawmaking is largely a technical matter with all sorts of devices that look counterintuitive to the sensitive conscience, but which are required to ensure bureaucratic and forensic administrability, and to take into account other needs that may be relevant to administration, and to allow a given provision to take its place in the whole body of social regulation. Details have to be settled rules of evidence, presumptions and burdens of proof laid down, bright lines drawn, operationalized criteria established, and so on. As John Finnis once put it, "Thou shalt not kill" is a legally defective expression. Yeah. But that's my point. It's now become, the law has become such that those sort of direct norms, "thou shalt not kill," are legally defective in themselves. And I'm not necessarily wanting to deplore this. The great problem in this lecture was tone. I want to sound grumpy, but I don't want to get hysterical. But let me get a little bit hysterical about fundamental rights, because that's the other category of public law where this stuff may be important. Some have argued, Michael Perry, for example, that human rights can't properly be understood except in religious terms, and I hinted at some ideas along these lines in the book about John Locke and Christian political theory. There's no doubt that the dignitarian terms in which rights are presented are open to that interpretation, even if they don't compel it. Certainly, human rights in the great international charters are expressed in deonic terms, at least in the great charters and covenants. Those documents are unabashed about referencing some supra-positive, beyond positive inspiration of those rights, and the formulation in the text of these covenants is explicitly presented as the positivization of what are assumed to be morally compelling and uncompromising ideas. So, for example, in Article 7 of the International Covenant for Civil and Political Rights, Article 7 makes the following no-nonsense claim: no one shall be subjected to torture. And other provisions make it clear that there is to be no derogation from this for any emergency or for any supposed necessity. So in the great covenants, even the word covenant is a great old-fashioned idea. In the great covenants of human rights, you have this uncompromising deontic normativity. But as they work their way into a municipal legal system, the deontic character of their formulation becomes diluted. Because remember, human rights provisions involve suprapositive ideas that are doubly or multiply positivized. They're positivized in international law documents, they're positivized often in the fundamental constitutional law of particular states. So in the second positivization of the torture provision in American law, for example, it's much more technical, it's much more Kelsenian. There's nothing equivalent to the formulation in the covenant that no one shall be subject to torture. Instead, there's a reversion to Kelson's directive form. The U.S. torture statute, for those of you who are interested, is Chapter 18 of the United States Code, Section 2340. The U.S. torture statute, which was, by the way, enforced throughout the entirety of the past couple of decades. The U.S. torture statute contains an elaborate definition of the offense. As used in this chapter, torture means an act committed by a person acting under color of law specifically intended to inflict severe physical or mental pain or suffering other than pain or suffering incidental to lawful sanction upon another person within his custody or political control, and so on. And then that's followed by a provision for punishment. Whoever outside the United States commits or attempts to commit torture shall be fined under this title or imprisoned not more than 20 years or both, and if death results to any person from conduct prohibited by this subsection, shall be punished by death or imprisoned for any term of years or for life. That, by the way, was why the administration got so nervous about torture law in 2003, because a number of people had been tortured to death, and this was a death penalty offense in American federal law. The punishments threatened are fierce, and they talk about prohibitions under this section, but the language "thou shalt not torture" doesn't get a look at it. There's not a lot of direct normativity in section 2340 of chapter 18 of the United States Code. And again, we could dismiss this just as a matter of drafting technique, which it is. But when the United States was actually faced with a years-long crisis about official use of torture in our black prisons overseas in the first decade of the War on Terror, all sorts of maneuvers were adopted to reinterpret section 2340 or to find indeterminacy in its foundations that could be exploited to make room for coercive interrogation. My former California colleague, Professor John Yu's technique of reading down the statutory definition is notorious. And the memo that he and Judge Bybee wrote from the Office of Legal Counsel also raised the possibility of a necessity defense against any allegation of a violation of the anti-torture statute. When you and Bybee wrote that the law ought to promote the achievement of higher values at the expense of lesser values, by higher values they meant the comfort and security of the American people. By lesser values they meant the deontological prohibition on torture. And similar arguments about possible necessity arguments, as you know, were made and conceded in part and in principle in the Israeli High Court's torture decision of 1994. The absolutism of individual rights is often taken as the leitmotif of American jurisprudence. Sean had quoted Robert Cullen about the importance of the rights motif. But in fact, although rights are spoken of as trumps and as absolutes, time and again courts prove themselves happy to balance and trade them off against each other, and not only against one another, but also against various considerations of the general interest. As Duncan Kennedy once said, talk of constitutional rights does not preclude open-textured arguments from morality, social welfare, expectations, institutional competence, and administrability. The rights are just legal rules, more or less abstract, more or less easy to administer, that we're trying to interpret along with all the other materials. In other words, our actual experience with rights in law is far from the sort of reverence for them that rights rhetoric would suggest. One or two philosophers, like my late friend and mentor Ronald Dworkin, may continue to think of rights as trumps, but in our actual legal experience, they're just ordinary cards played in ordinary suits, not trump cards at all. Like everything else in the law, they've been made attractive, negotiable, reasonable, in the sense of the rationalization of life. So all that is going on, or some of it is going on, a lot of it is going on, and you may say, well, so what? Even if law itself is developing and changing in these various ways, even if practices of drafting and the presentation of law are changing in these various ways, even if legal doctrines are changing in these various ways, still, are we not able to deploy whatever moral standards we like to evaluate the law as it is, and if need be, to denounce it? If existing legal practice doesn't seem hospitable to an absolute prohibition on torture, can't we, who are morally disturbed by this, use traditional deontological prohibitions to condemn it? John Yoo once said to me in a debate at Columbia in 2005, he said, you can listen all you like to Professor Waldron, but you need to understand there are no Kantians in government. There are no Kantians in government. But surely from outside government, we Kantians can say anything we like. We can bring our Kantian morality, our Kantian absolutism, if that's necessary, to bear on the practices we want to condemn. We might even use religious arguments against torture, as I've tried to do in various places, and as David Gushee and a bunch of others did in 2007 in an evangelical declaration against torture. And all this is fine up to a point. As critics, we can say what we like, and we can judge the laws that apply to us by whatever standards seem appropriate. And if we want to believe in moral absolutes, we can make morally absolute. Nobody take any notice, but we can make the arguments if we want to. And if moral evaluation of law were a purely personal matter, that would be a reasonable response. So purely a matter of determining one's own conscientious stance as a citizen. Shall I obey or not obey? Shall I be complicit or not complicit? Shall I vote for this or not vote for this? Then that would be sensible. One could deploy any moral standards that seem right or true. But in social and political life, one mobilizes shared standards to evaluate the law together. In criticizing a law for failing to meet a given standard, one offers that criticism to one's fellow citizens, and one expects what one is saying to make sense to them. And I'm not here just distinguishing between critical and positive morality, although that's a topic that positive morality is a topic that is much under-explored, very important in relation to historical traditions. But I am talking about modes of critical moralizing that seem natural, appropriate, and familiar to those with whom one shares the enterprise of evaluating positive law. And the worry is that at this level, the shared standards that make social sense, that seem appropriately put forward as a reasonable basis for the moral evaluation of law, also seem to be losing the deontic and sacred aspect of their meaning. The morality is going up in the middle as well. What I'm suggesting here is that the de-sanctification of law has not just been a matter of detaching law as an autonomous discipline from its erstwhile moral underpinnings. It's also been a matter of detaching it from old-fashioned moral principles and associating it, even if the association just remains critical, with the more tractable and calculable propositions of policy science. You know, I'm a legal philosopher, and I could put all this in terms of legal positivism. Positivists talk about the separation of law and morality. They don't intend that to mean that law should remain autonomous. Law is going to be evaluated. And they don't mean it destructively of morality. But what hasn't been given much thought is when you do separate law and morality so that you can get a non-wishful thinking statement of the law on the one hand and maintain the integrity of moral standards to serve as a point of criticism on the other hand, that the processes by which the two sides of that separation may have been subject are processes that may both involve desanctification. Right? We have desanctified law and we have desanctified morality so as to produce a morality that is apt for or appropriate or fits the law that we want to criticize. I don't mean we just invented a morality to endorse the existing law. We do want to change it, we do want to reform it, but we want to reform it with something that looks reasonable and calculable and tractable. So it's entirely consistent with the positivist picture that the Weberian processes and the other processes that I've been talking about also have an impact on the morality that is reserved for the critical appraisal of law, which is quite like its impact on law itself. So I'm inviting us to consider the possibility that the social processes that change the character of law also change the character of morality concomitantly. The rationalization and desanctification of law may be matched by isomorphic processes of the rationalization and desanctification of morality, or at least of any morality that can be plausibly put into play where legal evaluation and legal change are at issue in social and political deliberation. The morality that results is not necessarily tame or uncritical, but it subjects law only to certain kinds of critique, and it makes other moral critiques seem odd or quaint or inappropriate. So, for example, think again about Felix Cohen and the American legal realists. Cohen thought it was very important that we understand that law was answerable to morality. He said, don't be afraid of the word morality, because by morality I don't mean, this was his phrase, Sunday school morality. Yeah? I mean the modern science of policy. Sunday school morality, which mainly regulates the relationship between neighbors and neighbors' wives. Yeah, that's one thing, and people can go off and play with that if they like. But the morality I have in mind, he said, is a morality that is apt for, appropriate for, the spirit in which we want modern law evaluated. The problems of law today, he said, involve social forms or patterns that cannot be compressed into the narrow confines of Sunday school ethics. Only an ethics that squarely faces the problems which modern commerce and modern science have brought into our world can offer any worthwhile gifts to modern law. So there you just get a hint that as even this most reasonable of the realists wants to open the law that he's describing to external moral critique, at the same time he wants to transform our sense of what the external moral critique will be. All this from the side of the lawyers. What about the philosophers? Well, I think it would be wrong to deny that modern moral philosophy is also complicit in this new understanding of social morality. Its main features are a pervasive consequentialism and a reliance on reflective equilibrium to avoid any conclusions that sound dogmatic or unreasonable. I remember during a session at NYU a few months ago when Richard Epstein poured scorn on Immanuel Kant's suggestion that it was wrong in all circumstances to tell a lie, that there wasn't a dry eye in the house. Everybody was laughing heartily at this position that Kant had taken, and any attempts by me or a few others to try to see what he might have been getting at were regarded as preposterous. I remember during the torture crisis of 2003 to 2006, finding precious few moral philosophers who are prepared to stand for an absolute prohibition on torture. The usual response was, you can't be serious. They would say, of course, torture should be avoided in most circumstances, but you can't be serious that there are no circumstances where it could be used. There always has to be some necessity one could appeal to in order to excuse, if not justify, torture, or some technique of reading down the prohibition, or some indeterminacy in the legal meanings of the words like torture that would make these ostensibly implacable norms negotiable. It just can't be that there's just a flat, simple prohibition. We can't think in those terms now, morally, let alone legally. The thought seemed to be that effective but coercive interrogation just can't be something whose use is simply foreclosed a priori, as opposed to being rendered inadvisable in most circumstances. There are always ticking bomb hypotheticals that we can construct. There are always residual doctrines of catastrophic moral horror, which those of you in the trade will know of as a throwaway line by Robert Nozick, to mitigate the horror of morality's strictures. Jürgen Habermas talks of the erasure of the deontological dimension of normative validity within morality itself, and I fear he is right. Indeed, one or two philosophers, and I'm thinking here of Elizabeth Anscombe, conscious of this transformation, have suggested that it is actually the loss of the law's ability to sustain and process absolutes that has led to a loss of faith in absolutes in moral philosophy. If law has lost some of its moral bearings, morality is losing the bearings that it took from a conception of law. Morality used to be structured partly in a law-like manner. I remember when I wrote an article a while ago about the problem of moral absolutes, I said rather ingenuously, well, we can start from the law. Law certainly just prohibits certain things, and the prohibitions are just there, and you have no way of that. But that's not true. Law no longer has simple, straightforward prohibitions. Indeed, as I indicated, it's not clear that they have any prohibitions at all, as opposed to directives to punish certain forms of conduct. So morality used to be structured partly in the way that law was once thought to be structured. Now it's harder to see either enterprise as deontological. Law is no longer a role model for morality, and morality, I think, is impoverished because there is much less to be learned from law than there used to be. I mentioned the methodology of reflective equilibrium, and it's a similar problem. Though many people in moral philosophy are moral realists, what that mainly means is that they're willing to paste the label objective on the results that they achieve after they've done their best with reflective equilibrium. So we take a rule, we consider it seems unreasonable because it leads to certain outcomes that we wouldn't favor, so we make some adjustment in the rule, we make some adjustments in our evaluation of the consequences, we work a little bit at both ends, we finally get something that seems practical, and we paste the label of objective truth onto this. A deeper sense of objectivity would apply to principles that present themselves to us in a more uncompromising and non-negotiable way. These would not be treated as norms that we have this sort of control over. They would not be for us to read down or tamper with. Understanding such principles as divine commands or transcendent givens, we would think of ourselves as more passive in the recognition of principles appropriate for the evaluation of law than we modern philosophers take ourselves to be. I guess a third process has to do with the use of the idea of public reason, to make sure that in modern discussion, modern public discussion, as opposed to the privately reserved activity of morally denouncing this or that in public discussion we not present religious ideas, or that we not present moral ideas imbued with religion in public in circumstances where a large number of our fellow citizens either cannot comprehend them or belong to traditions that have not come to terms with these prohibitions. So I don't know, when David Gushee and his fellow authors of the evangelical denunciation of torture wrote that the cries of the victims of torture are like the cries of the Holy Spirit. What's all this about the Holy Spirit? You can't understand this, so that's not an appropriate intervention. The interventions have to be sanitized in advance so that they can be presented as intelligible and therefore civil contributions to public debate. The Rawlsian idea of public reason remains uncontroversial, as you know, but like reflective equilibrium and like this pervasive consequentialism, they are playing their part in, I think, producing a body of law, a body of morality that has been drained of a certain form of normativity. And that's a body of morality drained of a certain form of normativity, which is then apt for deployment in regard to the evaluation of a body of law drained of a certain normativity. I began with Max Weber. I'm going to circle back round to him again. As we saw earlier in this lecture, Weber's account of the processes we've been describing here is mainly formalistic. But Weber ends up matching that with a substantive thesis as well. In his great lecture from 1919, Politics as a Vocation, Weber maintained that a responsible person with a vocation for politics, somebody who really wants to get involved in effective deliberation about legal and policy matters, must, in a sense, commit himself, broadly speaking, to a consequentialist ethics. He said, there is a profound abyss between acting in accordance with the maximum of an ethics of conviction and acting in tune with an ethics of responsibility. In the former case, this means, to put it in religious terms, a Christian does what is right and leaves the outcome to God. While in the latter case, the ethics of responsibility, you must answer for the foreseeable consequences of your actions. Sanctity and political responsibility stand on opposite sides of the abyss. Somebody committed to an ethic of ultimate ends, as Weber puts it, is admirable in his way, but with his repudiation of actions that make use of morally suspect ends, he must be kept away from politics. A responsible politician cannot ignore the fact that in many cases the achievement of good ends is inseparable from the use of morally dubious means. It's just not true, says Weber, that nothing but good comes from good and nothing but evil comes from evil. But frequently the opposite is the case. Anyone who does not realize this is an infant in politics. Not just a point about consequentialism, partly a point about politics and law, which involve ultimately, as a last resort, the methods of violence. So the person who is legislating or making law or deciding a case is deciding ultimately about the use of force and must accept the responsibility for the consequences that might come from this apparently bad thing. Whoever makes a pact with the use of force for whatever ends, and every politician does so, is at the mercy of its particular consequence. So that sounds like now just a full-blooded substantive thesis of de-sanctification that Weber's putting forward very powerfully, quite humbly, and he thinks with the utmost urgency in Germany in 1919 for our consideration. Myself, I don't believe that this means that a responsible politician gives up on the very idea of certain actions being beyond the pale. In politics, certain actions just being categorically prohibited. It's one thing to say that actions for which you have distaste for must not be used. It's another thing to say actions that constitute abominations must not be used. But abomination is no longer a legal or a moral category. Well, as I said about 20 minutes ago, it was hard to know what tone to take in this lecture. A little bit out of my comfort zone with these materials. The English satirical magazine Private Eye used to have a poet who would write poems. He was sort of an old fogey, and each of his poems would begin, "Oh, isn't everything awful in this frightful moral age? Isn't everything awful?" And the tone of what I've said here today sounds a little bit like a litany of grumpiness and a certain sort of watered frustration. Obviously, I regard some of what I've described as deplorable, but the aim has been to describe de-sanctification, just simply to characterize it, admittedly from the perspective of someone who cares about it, not to deplore it. Also, it's easy to sound hysterical about all this, as though the processes described were utterly out of our hands. They're not. And as other people working in this workshop and in this room have shown already and will show over the next few days, there are ample materials of the sacred, there are ample materials of the divine even, still present in our law, or I assume they would think still present in the morality that we bring to the law. I don't think myself that we should be so complacent about that. True, in exploring these developments, I don't want to commit myself to a hard and fast version of these processes. We're talking at most about tendencies, which, as Weber acknowledged, have proceeded unevenly across legal systems and across areas of law for a century or more. This lecture has tried to describe a reduction, not an elimination, a reduction in the ease and naturalness of certain pathways of moral and legal thought, or an increase in the difficulty and sense of embarrassment accompanying certain pathways in legal and moral thought. And finally, the normative tenor of this lecture is supposed to be one of diagnosis and vague lamentation, rather than recommendation. No recommendations are on offer, except to extol the organisers of a conference like this, or daring to consider such relics of the sacred as may continue to be present in the law. I do believe myself that we need some sense of absolute categorical prohibitions in morality. I do believe that we need that in the law. I do think we should not be turning our backs in either sphere on a whole dimension of normativity. But the processes traced here, processes of de-sanctification identified by Weber and others, and processes of the transformation of moral thinking identified in moral philosophy, I think indicate how deep and difficult it may be to restore or get our way back upstream to that normative dimension in either of these two spheres. So that's it. That's all there is.
Thank you so much to Professor Waldron for the lecture, and we have a good amount of time for Q&A discussion.
Yes, sure.
So, as I heard you speak, I wonder whether you're combining the concept of I would like to hear you talk about the difference between sanctity and absolutism, because there's a way in which what I heard you say is that which is sacred is almost perforce absolute, and evidence of things not being sacred anymore is that there are exceptions. So I guess I have a few questions. One, you can imagine a realm of the sacred, but many exceptions. Right? You think about the laws of the Sabbath, the Jewish Sabbath, they're very sacred and there are many exceptions. So I'm not quite sure they go together. And then related to that, you talk a lot about American legal realism, and there's a way in which this presentation described like a moment in like mid-20th century jurisprudence. I'd like to hear you talk about what might be called, and I'd like to hear if you accept this, a resacralization of American law. And we can, of course, look at someone like Scalia, who speaks in terms of categorical absolutes, not in the sense of sanctity necessarily, but whether the keys are separation of powers and textual interpretation, and a lot of the irrational results that you seem to be pining for can be found in many statutory interpretation cases in which he says, yes, I understand this doesn't make a lot of sense, but this is what the law is, and if Congress doesn't like it, they can change it. So I'd like to hear your thoughts on this.
Thank you very much indeed. Both points seem to me to be important. I did kind of run sanctity and absolutism together, and you are right to insist that those be distinguished. They're somewhat separate phenomena. Although a moral absolute can have exceptions as well. Moral absolutes, the point that Anscombe once made, moral absolutes can be enormously complex in their formulation. It's just that their deontic normativity finally is non-negotiable. But you still, so you have a deontic prohibition on murder, but you still have self-defense as a justification. And you have the sanctity of the Sabbath, but you still have various exceptions to that. They operate in slightly different modes, I think. Absolutism is usually a character of a norm, and refers to the fact that whatever the norm eventually turns out to be, it is to be applied without consideration of extenuating circumstances, unless for some reason those extenuating circumstances are encompassed in the very meaning of the norm. So when we talk about the sanctity of promises, the sanctity of contracts, the sanctity of property rights, we sometimes mean something like the normative the absoluteness of the norms associated with them. Or sometimes we mean that these are going to generate obligation, and these obligations are going to have a tremendous weight, perhaps inexplicable except in some transcendent terms, a tremendous weight, and any consideration of departures from them are going to have to meet a high burden and be conducted with an appropriate degree of seriousness. I think the idea of efficient breach of a contract, which means effectively a decline of the notion of obligatoriness, is an example of the de-sanctification of contracts, even though there are lots of other reasons for saying that there are exceptions. So on that, I think I absolutely accept what you said. Resacralization of American law. I yield to nobody in this room in my admiration of the late Justice Scalia. And he was perfectly capable of sounding dogmatic and proud of it. And perfectly capable, actually, sometimes of saying, if that's legal formalism, so much the better. Hooray for formalism, when he talked about his textualist approach to statutory interpretation. So there was a certain uncompromising character to his formulations, and something like the normativity that might arise out of that might be an approach that could be put under the heading of resacralization, especially given the sense of the arguments for something like his textualism, which wasn't just as it is with some other justices or judges to try and put curbs on activist courts, but because these words command respect because of the circumstances in which they came to appear on the page, respect for the democratic process, and it has a certain amount of sanctity on account of that. In response, I would say that the tendency of many critics of Justice Scalia is to say not just that he's wrong about this particular link between the process by which the words are formed and the deference that's now due to them, but often the tendency is to say, no, nothing like this could possibly be true. Nothing like this could possibly be true. He's old-fashioned in this sort of way, so it's not just resacralization. This is like the last stand mentality of somebody who doesn't want to see everything go out the window. And I just tell one anecdote about Justice Scalia. He once gave a talk at Catholic Law School near Philadelphia.
Villanova.
Huh?
Villanova?
Villanova. He gave a talk at Villanova. It's something like, what's it like to be a Catholic on the Supreme Court of the United States? And his argument, as I understood it, was it makes no difference whatsoever because I'm a Catholic textualist. He said, but if you guys ever convince me of living tree constitutionalism, you better look out because I've got some very peculiar values about what the... Anyway, thank you very much.
So it wasn't clear to me whether you were conflating or arguing against the following three-part distinction. So we can ask about principles, probably also in law, but let's talk about morality. We can ask questions about their content, about their status, or about their epistemology. So absoluteness with regard to content, because this is now a follow-up of the previous question, right? That you may say some Jewish norms may be absolute in terms of status, fully objective, not up to us in any kind of way, but not absolutely free from content. And I take that to be a good distinction. Also, and you said something like that, the fact that we are willing to balance different considerations against each other somehow counts against the objectivity of moral principles, and I don't see how that is all related to objectivity. It's about the status, it's not about the content. It may be objectively true that everything is up for grabs, but that's about the status. And then reflective equilibrium, at least as I understand it, is about epistemology. It's not about the status of the principle, it's about our best way of finding out what the true principles are. Now, as far as I can see, at least absent some fairly serious further premises, these three features are logically independent of each other. You could go for more or less in any of them, unless you bring in many more premises. Nothing yet follows to any of the others. So how come they're all together in your thought?
Right. They are all together. They were mentioned separately. I think there are important connections between them, so let me try to explain some. Let's begin by focusing on reflective equilibrium, which presents itself, I think, in the first instance as a method, not as an epistemology. I've never seen any attempt to account for the relationship between the method and the idea of the pursuit of truth. And people announce it as a method, as an epistemology, but what it is basically is, this is how now we should do moral philosophy. Right? And although they are certainly prepared to slap the label objectively true on the results of reflective equilibrium, this process of adjusting the relationship between a given set of principles and a given set of intuitive or considered judgments, especially when it's dislocated from any sort of underlying intuitionism, I think leads it as a kind of method, and that method might be responsive to concerns about content.
It's perfectly compatible with objectivism, with intuitionism, with Platonism. It's just our best shot at finding out the truth or approximating.
No, it's perfectly compatible with each of those epistemologies, but it has no epistemological content. I mean, this would be a longer conversation to be, but it has no epistemological content in itself. That doesn't mean to say that it necessarily coincides with either of the two other things that you mentioned. But it does seem to me to be it's a method for reducing any apparent lack of congruence between what we find reasonable and what we can state in very general principles.
Why do you care about reducing lack of congruence?
I don't care about reflective equilibrium.
Why does one care?
Yeah, it's partly because something like they don't want to end up holding something which is uncomfortably.
It's because non-congruence is conclusive evidence of falsehood. You care about truth. This is your best shot at approximating. I think you can find this in Rawls too, but Rawls was also a constructivist, so all hell breaks loose. But there are many people who are not constructivists in any way who will go in for this kind of epistemology of morality. And in fact, we defend it as a particular instance of a similar kind of epistemology everywhere else.
So we disagree about that. On the other point about content and state, it's certainly true, this goes back to the discussion with the previous question, that there's no guarantee that absolutism has to be pitched at any particular level of content, that absolutist principles have to be 15 words or less, that they can't have complexity. And the identification of that complexity can sometimes be disconcerting to a deontologist, and they can sometimes respond to it with this sort of grumpiness, and that would not necessarily be appropriate. But sometimes there's a sense that, as it were, if something is presented as categorically prohibited, that must immediately elicit attempts to show that things must be more complicated. And the thing that is more complicated that is presented is itself no longer presented as categorically prohibited either. It itself is liable for continual revision in light of consequences. Balancing interests against one another is, of course, in certain circumstances required by all sensible moralities. But the suggestion that balancing is always to be undertaken as the essence of moral inquiry is partly what's going on here. Now, the relationship of either of those possibilities, the balancing stuff and the complexity of the content to the issue of status is, I think, complicated. One thought is that if we accept that certain norms have as it were, a status in terms of where they come from, who they are laid down by, what their immediate application to us is, then that generates a certain sort of hesitation to immediately subject them to balance and to think, as it were, things have got to be more reasonable than that. On certain views of the status of certain norms, we have to accept that things may not look comfortable. We may not be comfortable. They may not look reasonable or appropriate to us, but none the worse for that. It doesn't follow that any attempt to plumb their complexities is inappropriate, but it means, as well, there's going to be kind of a tendency in that direction from the thought about content. I don't know that I can say anything more about the reflective equilibrium point. People are embarrassed by it, especially in philosophy classes and in philosophy departments, by holding views that are inconsistent. And certainly an inconsistency, a formal contradiction, is false. So it could look as though this is primarily understood as a means of aiming at the truth. We just eliminate successive waves of contradiction. But again, I don't see in the literature on reflective equilibrium any suggestion that, as it were, this method helps us to select the few consistent but true positions from the many consistent but untrue positions. I don't see any. All it does is eliminate the inconsistency. It doesn't give us the help that we need epistemology to give us, namely, tell us how to distinguish the consistent but false positions from the consistent and true positions. And I don't see anything in the theory of reflective equilibrium that's ever been supposed to be. Shai.
Thank you. I share your concerns, and I share your grumpiness. But I'm not sure about the solution, and even more, maybe this is where you're hinting at, but I'll just say it in this way, that I think that what you see as the solution is actually part of the problem. Not just the absolute, but also Kant. So if you could say more, I'll explain in just in 2 words why I think they're the problem, not the solution. But then the real question is, how do you understand the problem that we're facing? And so Kant seems to me to be part of the, in some ways, okay, he saves us from consequentialism and from a certain kind of policy, and I see that and I respect that. But Kant emerges at more or less the same moment that all these things are happening. And what Kant does is tries to place morality on human rationality. And this is, in some ways, in many ways, exactly what the policy people are trying to do. And he discards anything else that could, bring humility to human beings trying to engineer the world in the way the policymakers are trying to do. He removes history from the story. Humans become the center of the story. Universal reason. Religion, as we were discussing earlier, needs to be totally abstracted from any, from Sunday school in some ways. And so what we're left is an absolutism that I think is a kind of modern fundamentalism, which can be understood as a response to the rise of utilitarianism, but is part of the same game. And the idea that so I could go on this, but just to say, I'm not sure at all that the concept of God is the concept of the absolute in this Kantian sense. It's much more goes along in my mind with the idea of the sovereign as the absolute, to the view, and the modern phenomenon of sovereignty as absolute. And I guess what I'm asking is, are we trapped in this deontology versus consequentialism? Is this the whole story that can be told? Or whether there is something else, and whether once we give up on deontology, we're immediately sucked into the idea of policy making and de-sanctification, or whether there must have been alternatives. I mean, in Rome, no, but the officials in Rome weren't Kantians either, but they weren't the modern bureaucrats that we have today. So this is kind of the.
Let me just make a note of that last point. We'll come back to it. Yeah, you're right about Kant, and I was using the Kant as a technical term rather than referring to the old spider of Königsberg. I don't know whether I describe him as part of the problem, but the way you describe it sounds sensible to me. He thought, you're absolutely right, he was not a religious thinker about ethics. and he thought it was human rationality and the processes by which we would plumb and explore the bearing of human reason on moral issues that would be important. And sometimes that would lead to deontological ideas, and sometimes it wouldn't. And sometimes it might lead to deontological implications on fewer occasions than Kant himself thought. I was partly taking my cue from John Yu's throwaway line about there are no Kantians in politics, and from Richard Epstein's discussion of Kant online. But I concede all of that. On the point about is it just a consequentialist deontology standoff? Thanks for that, because I think the answer has to be no. One of the things that's hard to bring to bear in modern policy science are concerns about justice and concerns about dignity. You know? And those, I mean, although they have a sort of vaguely deontological flavor, let justice be done though the heavens fall, and human dignity must be respected come what may, they can also be presented as powerful and compelling parts of a value theory. And modern policy science finds it very, very difficult to accommodate thoughts about justice. When I talk to my law and economics colleagues, they say, yeah, well, some people value justice, so we'd have to see how much they're prepared to pay for that and factor that into the circumstances. I say, no, you don't understand. They're proposing a fundamentally different matrix for the social welfare function. And similarly with dignity, in some discussions I had with Cass Sunstein, I say, you're talking about autonomy, right? He said, no, I'm talking about human dignity. He said, right, autonomy. And of course it's possible that all these can be presented, these ideas can be presented in the context of a moral structure that wouldn't look particularly deontological. It would just insist that when we are assessing what's happening as a result of what we do, we must give powerful and overriding importance to this array of consequences, or to this pattern of consequences, or to these particular consequences. So I don't think it's deontology or consequentialism. Again, forgive me, it was a simplification. But I do think that the problem that we have lost a strong sense of deontic normativity is important, even if it's not the whole story. Suzanne.
So this is part of rephrase of Shai, but perhaps from a different angle. So that there are varying stories about the disenchantment across spectrums.
Yes.
Right? And the story is one in which, right, increasingly, right, the world is disenchanted and law with it. And what you're pointing out is just how far that disenchantment has really corrected the law. But what we also are witnessing now is that Weber was quite wrong about whole parts of our life experience. There's a dramatic resacralization, right? Especially in religion. Religions are actually in a phase in which they are quite resacralized. And so my question really is, in those conditions, right, what really is what we would want to expect and see from law? Is it maybe absolutely, is it maybe really a giant cost that we have to think about and weigh when law would become resacralized following the resacralization of other domains? And here, I mean, in a nutshell, in a way, there's the problem, to some extent, the cover identified. What does a natural lawyer do in conditions of radical pluralism, where people have really serious understandings of what is the sacred and they're quite different? And yet, so for example, in human rights, as an example of it, religious communities can hear well that something is a matter of convention, consent, law at a low level. What they can't hear is a competing, right, sacred domain. So here's what that's one question. And I have a
I see. I already saw two. Yeah. So there is a resacralization going on, if we're not mistaken. Maybe not in social life generally, but the religions are becoming becoming more unruled and becoming more insistent on the sacred parts of their heritage. And that may, God willing, have some impact on how law deals with these matters. Now, if it does have an impact on how law deals with these matters, it has to have an impact on how law deals with these matters in the modern world. And the modern world being a world of pluralistic societies, we have to look at with what normativity will the law approach the problem of how to persuade peoples and communities to live together. With what normativity will law insist on respect between rivals and Muslims? With what normativity will law patrol the outer bounds of what's tolerable, even within a religious community? And as I understand it, those issues have suffered a certain desacralization, even so stated, quite apart from the issue of particular religions dealing with their particular adherents and their particular doctrines. So I see the importance there of resacralization, which would be an insistence on the power and compellingness of standards of toleration, of standards of mutual accommodation, and standards of mutual respect. I mean, as I said earlier, the resacralization of life, I hope it's true. It could be true and intensely uncomfortable. It could have momentous and very bad consequences, because there's no guarantee that normative form in this sense will always be associated with good and appropriate norms. But eliminating this aspect of sacralization from our normative repertoire seems to be Ori.
Thanks. So one point has to do a little bit with these ideas about connecting sanctity and the absolute.
Yeah.
So it's not so much about exceptions. I think you can have things that are sacred that can interact, right? Can overlap, and then you can live with two things that are sacred and still, as a practical matter, come up with some kind of solution. I'm not sure sanctity takes it to the absolute. It's not a point about exceptions so much. And I think Jewish law has all sorts of these kinds of cases. What happens when the Sabbath and Yom Kippur fall on each other? You have two sacred things. And also there's something a bit monotheistic, maybe, in this connection between the absolute and the sacred. You can think of other kinds of religions where it's much more effective. And you still have sanctity, but absoluteness, that's one point. And 2 points about the lamentations, or the vague lamentations. So one is about the connection between sanctity and the ontic, right? So I took it that at the time, 19th century, one of the reasons to get rid of the deontic was exactly to get rid of the religion in the law, right? Why? Well, the religion comes in with these deontic requirements, and it brings in religion, right? So it imposes religion, and there's all that story of toleration. And then sometimes religion is kind of not moral, right?
Religion is what?
It's not always moral, right? It's a placeholder for power and all sorts of stuff like that. And a lot of the reason to get rid of all of this was exactly to get rid of the sacred, so-called. So there is that aspect to it in terms of the lamentations. I mean, the standard story was this is a good thing, actually, that we're getting rid of this. And finally, I was wondering if your lamentations were that of the law professor in America. Not of the American law professor, but one that is in America. Because the story you told was very much kind of a Holmesian story. The future of the law, right, and the path of the law is exactly where it is. It's going to be controlled by the economists and the empirical people, which is exactly what's happened. But the question is American legal academia a reflection of the realities of the law, Scalia, America, but also outside of the law? So think of the human rights movement. That looks very religious to me. Also, in the way it simply operates, almost, it seems like a religion sometimes. Not only the content. And the law in many other places is very religious, right? This is not New York, where we are here. And think about other places. It seems like the law in many places is actually getting more religious rather than less, realism notwithstanding.
There's certainly a variant story to be told about how religious law is on the decline, but the pattern is massively uneven. But what you say is right, it's not even on the decline necessarily, it's on the increase. Yeah, there's a certain parochialism, inevitable just to a 45-minute lecture that has to have some detail. But I think you're absolutely right that there was a conscious attempt to get rid of some of the manifest irrationalities of religion by effectively eliminating natural law discourse as a major component in our thinking about the task that positive law needed to perform. A lot of baby gets thrown out with that unpleasant smelling bathwater. One is we lose the ability to relate what we are doing with the law to our deepest sense of ourselves and of who we are and of the tasks that face us. We end up having a relatively superficial account just because we worry that as soon as you open the door to more serious, profound accounts, you will get unpleasant accounts, which you certainly will. So, but I don't deny what you say about the history. And one way of reading all of this is that this has been a product of this has been a matter of the extirpation of some very unpleasant irrationality from human affairs, both in the law itself, in the morality with which we confront the law, and in the religions that are sometimes deployed to back that up. Now, on the first point that you made already, that things can be sacred, and multiple things can be sacred, and often there can be a certain degree of uncomfortable accommodation between them, and one's willingness to concoct such an uncomfortable accommodation surely can't be regarded as a derogation from sacredness. I think that's right. And so again, it shows what's been a major theme of these questions is that I shouldn't be in the business of associating sanctity and absolutism in a mechanical way. It's right also in a deeper sense. One of the themes in Weber's account, if you remember, is that we have a kind of a new polytheism. You mentioned that there would seem to be a certain monotheism in what Waldron is presenting here. That there's a new polytheism. We have multiple values and not always commensurable. Things are always in a lot much messier than any erstwhile systematic natural law deontologist would have them look. And even they are having to come up with uncomfortable compromises in the fraught circumstances of human life. And I omitted that just mainly for reasons of time and space, that other theme of Weber's, which is that we have to deal with now a multiplicity of values, not just the multiplicity of different creeds that Suzanne was talking about, but even amongst us in our own heads, a multiplicity of different things that we think matter in human life, and even that we may think sacred in human life. So theorists of justice have to deal with this, and theorists of dignity have to deal with this as well. So, thank you. Yes?
So you spoke about basically a trajectory of de-sanctification, of a decrease in the sanctity we attribute to both law and morality. And you concluded by talking about the public sphere and our inability to hear those voices in the public sphere. And that made me wonder if what's actually happening is just a process of decreasing sanctity, or if actually there's a kind of vacuum that has to immediately be filled. And whether what's actually happening is that we're attributing sanctity to other things. Meaning that the reason that in public discourse we can't hear absolutes is because we're actually sanctifying other things, sanctifying the kind of liberalism that maybe has a certain aspect of, we're sanctifying tolerance, we're sanctifying maybe a certain kind of relativism even. And that's actually what's being sanctified. So the sanctity is not disappearing, but it's actually transitioning somewhere else.
Yeah, that's possible. When I answered Suzanne a little while ago, I suggested that in a modern resacralized world, if absolutes are going to come back in, they're going to have to sanctify relations between different creeds. They're going to have to sanctify the relations of respect that are required to make a pluralistic society work. Those things are going to have to, in a way, become absolutes, and so there's going to have to be some migration of sanctity from within particular creeds to the in-between of particular creeds. But I also wanted to insist, so I accept that that migration would be called for. Whether it's happening, I'm not sure. Certainly, if somebody makes an intervention in a public debate in religious terms, among a certain sort of audience, it may well be an audience of American law schools, there's a sense of distaste for the intervention. Sometimes it is presented as though this is an affront to the rights or to the duties of tolerance that we owe to other individuals who are not of the heritage of the intervener. But a lot of what is said is simply that it's a matter of civility. We can't make sense of this stuff. And then one says, well, have you tried? And they say, of course not. After all, they say that, look, the universities and the cities are groaning with libraries and art galleries, and churches are festooned with the requisite material. Why don't you read the Evangelical Declaration Against Torture and then go to the library and look up the difficult terms? No, we can't do that. When Habermas suggested that there's got to be some sort of impulse towards a two-way translation, so that those who hear as well as those who speak sacralize language in public debate have an obligation to try to render it in each other's terms. There was quite robust denunciation of that. So I accept a little bit, normatively and descriptively, that there's some migration of the sacralization from the content of what is said by anybody in particular on any particular topic to the relations between the speaker and the audience, the relations of respect, the relations of civility. And as I said to Suzanne, I think it's important that that take place and that that not be blocked. But I believe it is also important to insist that voices of the sacred be heard in public life, and that citizens have an obligation to try to make what they can of that, and listen to traditions other than their own, and listen to traditions where they don't have any corresponding tradition of their own. And not that that's a sacred obligation, we're talking about conditions of delivery, but it's an important obligation. And at the moment it's met with what purport to be deontological resistance. Yep. You are denying me my religious rights by preaching to me about torture and the cries of the Holy Spirit. Rather than, I wonder what he means by that. That sounds serious. Maybe we should look that up before we torture anyone else. So, what's going on?
Would the return to absolutes, or let's say a Dworkinian enshrining of value, would that be sanctification in your terms of sanctification, or does it necessarily encompass something like you just answered, listening to other religious articulations of that?
Right.
Yeah.
Right. I was using, as I hope I acknowledged from the beginning, de-sanctification in a staggeringly loose sense. And it could just mean a draining of a certain sort of normativity. I'm not assuming that de-sanctification necessarily involves a closing of yourself out from certain traditions, but it often does. It often does. Sometimes, again, as Suzanne reminded us, it's the artifact of somebody having listened hard and not liking what they hear. So it's possible, just to take up the first part of your question, it's possible that one could, as it were, take much more seriously, say, values associated with dignity and justice, without necessarily having to give a religious tinge to it. I myself believe that that's going to be difficult. Other people, like Ronald Dworkin, believe that it would involve having to invoke some secular notion of sacredness, and that would be important. But here's the thing, and here is where I do accept your point about listening. If you talk about the requirements of justice, and you mean by justice not just a general theory of social policy, but as it were, as the most important stuff without which a society should perish. Yeah? When we talk about justice in that compelling sense, what reason would we have not to listen to everything that is seriously put forward? Yeah? Or to think we can afford to ignore those guys who say that there's something transcendent about this stuff. Similarly, if we talk the language of human dignity or fundamental human equality, why would we not want to listen as hard as we can to the stuff that is supposed to be what is most important about human beings? And we would listen to Kant, though he's not religion, and we would listen to Locke, who it was, and we would listen to this bishop and that rabbi and this imam and so on. Listen as hard as we can because the stuff is that important and that fundamental, and there's no reason to think that religion is not addressing.
I think we have time for maybe one, maximum two. Maybe we should collect 2 questions and then you time to respond.
Okay, Sean.
So I wonder if you might add to your observations the following. That is that I find that the way in which we describe legal education today is often in terms of problem solving. That is that students learn law in order to become good problem solvers. So first that kind of has this ring of calculus or math misunderstood, right? Mathematics misunderstood. But it also, I worry about it also gutting the notion of legal education from learning about justice, becoming an agent of justice, and also gutting it of an acknowledgement of complexity and uncertainty and the need for humility. So, so I just wondered whether I would, you might line that up with your observations in terms of how we talk about law, how it's practiced, and how we actually imagine the point of learning about it and becoming a jurist.
Right. Thank you. I'm going to answer two questions.
Yeah.
Yes, so one corollary of sanctification is demonization, which is one of the things that we try to avoid through
demonization,
through civil law and
yeah.
in the middle of it.
Yes. And just to get clear, you said demonization.
Yeah.
Yes, indeed. Thank you very much indeed. I don't know whether, I'm going to answer that first and then come back to it. I don't know whether demonization is a corollary or even a necessary opposite of sanctification. I would really, I hope not. That's right. I mean, there's a certain sort of knee-jerk Schmittianism which is just wrong here, that you can't sanctify anybody unless you demonize somebody, and that you can't place great value on the one without placing the value on the other.
But in popular religion, it tends to be like that.
So, sometimes it tends to be like that, and to our disgrace, sometimes it has that effect. But there are a great many traditions that don't have anything of that character. And I think it is perfectly possible to say that in human life there are going to be certain things that have to be held to be sacred, and certain other things that are silly to regard as sacred. Now, that doesn't mean to say demonizing the latter, but just working on them like one works on the roads, rather than working on them as a great issue or problem of human rights. Which brings me to what I wanted to say to Sean. I'm not as convinced as you are that this language of problem solving as an overall description of what the task of the lawyer is bringing bad consequences or bad atmosphere here. But I'm not confident. Let me just say why. So we have some desperately difficult issues. I don't know. A lot of single mothers are bringing up children, and the fathers of those children are not contributing, many of them because they have other families that they're trying to involve. So we have a problem of justice, right? And whether in particular cases or as a matter of policy, that problem has to be solved. The problem solving is not just a matter of calculus and calculation. We have to solve it as a problem of justice, right? We have a bomb that may have been planted by somebody who's come into the country, and we don't know where it is, but we have some of his accomplices. and we have a problem of security. And the question is, can we solve that problem in a way that is compatible with our respect for the dignity of human individuals? So just for those reasons, it occurred to me that although there are many, many ways in which the problem-solving mentality and the technician description of the lawyer can lead to a bad atmosphere or a bad approach to legal education, I don't think it needs to. I think it's perfectly possible to say, no, if you're going to be a lawyer, you're going to be sometimes dealing with values that are of the utmost importance. Sometimes you won't. It's just a real estate problem, right? Or just the problem about some particular transaction. But sometimes you're going to be dealing with issues that are of the gravest importance. And you've got to be prepared and educated to do that. And what's more, there's no telling when this will come up. And you've also got to be open as a lawyer to reconceiving the problems that you face in terms that seem a little bit more transcendent and a little bit more involving the sacred. Even if it's just say, oh, so I'm faced with an issue about bankruptcy. Isn't that a problem of justice? Justice as among this body of creditors and justice as regards the situation of this person who has gotten themselves into financial difficulty. So it sounds like a possibility of surrender, but it's not. That the language of problem solving can be rendered compatible. Thank you for the question.
We just, I think, experienced a sense of re-sanctification of the law having Wולderron in Jerusalem.